Good morning, ladies and gentlemen and members of the Beit Din. I am here representing Rachel Rubenstein. Ms. Rubenstein is the owner of a new state-of-the-art self-driving car developed by Aliva Industries. On the day in question, Ms. Rubenstein got into her car, turned on the ignition, and enjoyed the drive. As the car proceeded on its programmed path, a pedestrian ran into the road and the car automatically veered into oncoming traffic, as it was deemed a safer option. Since Ms. Rubenstein could not participate in the decision to swerve into the opposing lane, it is our opinion that we should not be held liable for the injuries sustained by Mr. Shalom. We believe that liability rests solely with the companies that engineered and programmed the vehicle. However, even if this Beit Din decides to attribute a portion of the liability to Ms. Rubenstein, we believe the car manufacturer and software company should share the blame and be held jointly liable with Ms. Rubenstein. Finally, the programmed actions of this vehicle might possibly have saved the life of a pedestrian, even though Mr. Shalom sustained injuries, as the programmed response of the car resulted in an act of pikuach nefesh. We would ask the restitution Mr. Shalom seeks should be tempered in light of the fact that no one was killed or permanently disabled.
Good morning. Good morning. I represent Mr. Shimon Shalom. Mr. Shalom is seeking restitution for injuries sustained, loss of time from work, and damage to his car as a result of an accident which occurred with a vehicle owned by Ms. Rachel Rubenstein. We recognize that we have the burden of proof in order to succeed with our claim. According to Mishnah Bava Kama 3:11, the burden of proof falls on the person seeking damages in order to secure restitution for their losses. Since there are at least 2 eyewitnesses to the accident, it is our claim that this burden has been satisfied. We further contend that the incident happened so quickly, Mr. Shalom was unable to avoid being hit by Ms. Rubenstein's car. We recognize in bringing this case before the Beit Din that Jewish law has evolved to make a person whole through monetary damages. We have relied on Mishnah Bava Kama 8:1 and 2, which outlines compensation for injured parties for actual losses. Even though Mishnah Bava Kama 8:1 and 2 also mention embarrassment, we do not seek restitution for this, since Mr. Shalom did not suffer shame as a result of this accident. Further, while Mr. Shalom has made a full recovery, he spent several months in the hospital, and his medical bills, auto repair bills, and lost wages due to the accident have put him in a great financial difficulty. Therefore, we are seeking monetary damages to become whole again.
The question before this Beit Din is whether Ms. Rubenstein can be held liable for an accident in a vehicle she did not control. We hold that Ms. Rubenstein is fully liable for damages and rewards full monetary compensation to Mr. Shalom. We learn from Mishnah Bava Kama chapter 2, verse 6, that human beings are habitual damagers, whether it is accidental or purposeful, whether they are awake or asleep. Her lack of control, in the opinion of this Beit Din, does not diminish her liability in this instance. Ms. Rubenstein assumed a series of risks when she got into her car and proceeded down the road. The spark created in starting her car is most like the fire, which may move in both intended and unexpected ways, as noted in Gemara Bava Kama 9b through 10a. Further, we learn from Shemot chapter 22, verse 5, that when a fire is started and spreads, he who starts the fire must make restitution. The basis of our opinion comes from analysis of 4 different types of damagers: the pit, the ox, the chewer, and the fire, as referenced in Mishnah Bava Kama chapter 1, verse 1. We have evaluated each potential damager and have rejected the initial 3. The pit, which is unlike the car and is inherently dangerous without movement. The chewer, a living entity which cannot be trained to move in familiar ways. And the ox, which according to Gemara Bava Kama 9b through 10a, can be either more or less dangerous than the fire depending on circumstances, but is a living entity which will respond in unpredictable ways. However, the stadium ox, as referenced in Mishnah Bava Kama, chapter 4, verse 4, is trained to repeat behaviors, and we feel this warrants this Beit Din's analysis. We would argue, though, that there is no equivalency with programming a self-driving car and the stadium ox, because the ox will move in a familiar pattern of limited trained behaviors. More importantly, the self-driving car can be programmed to respond differently in multiple situations, and has been designed to save lives in line with the concept of pikuach nefesh, as referenced in Tosafot Bava Kama 60b.
Pikuach nefesh is at the core of our ruling.
Had the self-driving car failed to respond as it was programmed to do, the pedestrian most likely would have been killed. Although Rashi argues in Bava Kama 60b verse Vayatzi law against damaging another's property for the sake of Pekuach Nefesh, this Beit Din finds its opinion aligned with that of Tosafot Bava Kama 60b verse Mahu, in which you can find that it is permissible to damage another's property in order to save a life. We should also note that even though Mr. Shalom is an injured party, we live in an age where technology is amazing and is capable of saving lives. Those who come before our Beit Din seeking restitution may find that we will look at the totality of the situation if lives were saved in determining a fair amount for the damages. We would like to further amplify why we are declaring that the self-driving car is like the fire and unlike the other types of damagers. The driver of a self-driving car is forewarned that when they ignite the fire, this vehicle will always have the propensity to damage another's property and move in unexpected ways if the program senses that lives are in danger. As it says in Gemara Bava Kama 22a through b, even if the fire spreads on its own, he who set the fire must pay because it was set with his arrows. The nature of this case has caused this Beit Din to consider whether or not to instruct Aliva Industries to alter the programming used in their self-driving car. We have determined that the companies involved will not be held liable in this case because the car performed as it was programmed to do, resulting in an act of Pekuach Nefesh. However, we implore Aliva Industries, in conjunction with the car manufacturer, to add an emergency override feature or a manual brake, or face our scrutiny in future if there should be technical failures. The goal, according to our halacha, is to assess liability, determine the extent of the damages, assess what the damager must pay in conjunction with any insurance company payments as explained in the responsa of Rabbi Sternbuch, and to instruct the parties that restitution should take place in a timely manner. In conclusion, this Beit Din rules against Ms. Rachel Rubenstein and orders her to make financial restitution to Mr. Shimon Shalom. Thank you.
Judges, you now have 8 minutes for questions.
So, one of your main arguments has to do with fire and who started the fire and therefore responsibility in suing. In your written case as well, you didn't consider whether Mr. Shalom also assumed some of those risks. Mr. Shalom also started the fire by being in his car. Can you tell me, does he have any responsibility at all because he also started his own fire in this accident?
So perhaps the greatest difference between the car that Mr. Shalom started and is driving and the car that Ms. Rubenstein is driving is the fact that Ms. Rubenstein has no physical control over the car. We would definitely compare Ms. Rubenstein's car to the fire in which you start it and then you have no control over its spreads. It can consume both appropriate and inappropriate things, destroy things. Mr. Shalom incurs the risk that he took on of driving his car, but in this case, he is not liable. First of all, because the damage was done to him, but furthermore, because the car itself, Ms. Rubenstein's car itself, had no ability herself to drive the car out of the way. That is why we suggest a manual override function to make sure that, and to directly address your question, sorry, Mr. Shalom incurred his own form of liability, thank you, but is not responsible in this case because he was able to control the car and did not make any mistake.
So as a follow-up
Please.
question then, you did the ox, the chur, the
course.
fire, and the pit.
Yeah.
Would you say that Mr. Shalom and his car represents any of those four or neither?
Okay. Would you like to go?
Yeah. Actually.
We have found that in this case, he didn't really do anything wrong because Ms. Rubenstein's car could not signal. She could not honk. It didn't make any warnings. So from the perspective of American law and with Jewish halacha, he was doing what he was supposed to do. He was driving down his side of the road, and he did not know to expect that something would happen. Therefore, you cannot really put any blame on him because in this case, he wasn't doing anything wrong.
So, in another response to your question, this would take a significant more amount of, we could probably write a whole other written opinion about this. But and I think this Bateson would find that the car is most like the ox, and we would have to go through a stricter analysis of whether that be the stadium ox or whether that be the typical ox that does not gore or that is not trained to gore. For a multitude of reasons, and I don't want to take up all the time, but specifically that the ox has the ability to make movements as the human is driving and intended decisions as the human is driving the car.
That works, I'll pass it on.
Okay, really quick. Okay, so you guys claimed that Rachel was forewarned. But in my information, in my background information about Oliva Industries and their cars, is that in fact there had been no prior circumstances of anything like this happening. So therefore, how could she have been forewarned that something like this could have happened?
Because the car is classified as the fire, and by starting, like, the controller of the fire is automatically forewarned.
Okay, I'd like to follow up on that question. So, are you saying that the classification for damages creates the liability?
No.
Is
No.
that what you're saying?
No.
Because it sure sounds like it.
So I think it was just a misstatement of saying one thing before the other. But I think what we're really getting at here is that it is the fire. However, just like when you incur the risk of starting a fire, that same occurrence, and there had been no prior circumstances. However, the programming itself was designed to save lives, and she needed to know that she had no control, thus she was at the risk of anything the car chose to do. Any mechanical malfunction, that would have been the Oliva Industries' fault. But, you want to follow up?
Well, your point is well taken.
Okay.
I want to just take it one
Please.
step further. So are you arguing that Rachel has liability because she did not foresee this happening?
Not at all.
No.
This particular event happening?
We are
Then
not
what is the
saying,
role-
okay.
My question is, what is the role of foreseeability in your argument?
The role of foreseeability in our argument as we created it as a team, we kind of read the situation, we interpreted as she chose to start the car. No one made her do it. When starting the car, she understood that things could go wrong and that sometimes they do go wrong. However, in this case, we're not holding her liable because something did go wrong and we just assumed she would know it would.
So how do you explain the Rashbaum's statement about when a gust of wind comes and creates some kind of danger, the defendant is exempt?
So, the gust of wind in this case was the pedestrian. We didn't directly address it in our written opinion, but we feel that the unforeseen circumstance that happened was the change in what happened. The self-driving car was programmed and acted effectively to that gust of wind, that unforeseen circumstance that happened, and in fact, that there was no mechanical error. That's the car which she bought and is in charge of and is liable for, acted correctly. That is her responsibility, as she was the one who started the car and assumed that liability.
I have one other question, if you don't mind. So if I buy an electric toothbrush
Yeah.
at Walmart that's made by Colgate, and the electric toothbrush, I'm using it, and the electric toothbrush is plugged into the wall, I turn it on, and instead of brushing my teeth, it explodes in my face. Am I liable because I turned the electric toothbrush on?
Not at all. Simply
What
because
is the difference between
absolutely.
that and the automobile?
The difference between that is that I think it is a mechanical failure. When there is mechanical failure, that is specifically the time when Oliva Industries would become liable, and that is why we put them in our case on notice that if anything happens again,
They can be held
they can be
liable.
held liable if there's a mechanical failure. That is why we've instructed them to put in the brake option. So then anything in the future, it's their fault. With the toothbrush example, that is not what a toothbrush is supposed to do. That did not result in pikuach nefesh. That
It's a
wasn't,
mechanical error.
it's mechanical error, so that is why, that's the difference.
I have one more question, and that has to do with the restitution. You have restitution for medical, loss of work, but not embarrassment. Could you at least explain why there is no embarrassment at all in this
Mr.
situation?
Shalom did not suffer embarrassment through the accident. He got injured.
Time.
Thank you.
That's all.